Hello and welcome to this third in the series webinar by Kingsfield Academy. Thank you for joining us. You can see that I'm joined again today by John Fotherby and Karen Sherrill, and in the background is Wayne, as ever, doing all the IT bits for us. So just to explain that this being the third in the series, this webinar, and what we want to do here is to address some of the questions that have been put to us by the first two webinars. What we're going to do is it's a 45-minute webinar. We're going to have 35 minutes looking at the questions that have been proposed to us. And that's going to be mainly led by John and Karen. And then in the final 10 minutes, again, we'd like to do some live question and answers with you. So for those of you that were on the previous webinars, you might be familiar with that. If this is your first webinar, then you will see on your panel, on your screen, that there is both a chat box and a question box. Please write your questions in the question box and they will get filtered through to me and we'll address those in the last 10 minutes. Just to talk a little bit through today about what we'll be covering. So there's going to be 6 areas we're going to be looking at. These are going to be demonstrating impact and mitigation, foreseeability, notices of force majeure, governing law, alternatives to force majeure, and signing new contracts. And I think probably what we'd like to do, I mean, these are all pretty much interconnected topics anyway. I think probably what we'd like to do is start with what was the most interesting and challenging topic, and the one really that came out on top of the polls in the last webinar. And this is going to be the demonstrating impact. I think what we'll do first is let's start with a poll and get a few opinions out there to start with. So if we bring up the first poll. So are we seeing that poll? Are we, hopefully we're seeing a poll. Hopefully we're seeing a poll that says, what do you expect to be able to recover on your projects? And the options are time, money, both, or other relief, for example, reduced scope. So I did mention briefly as well about the other 2 webinars, which we have done. And so just while we're waiting for these poll results to come through, I think you know, it's worth pointing out, if you missed those webinars, then they're available on our YouTube channel. So please, you can see them there. I'm just having a bit of an issue here at the minute about.
So, Carl, if you can't see that, the poll results are up there, and 44% of people want to recover time, and 56% of people want to recover both. So, so we're looking at both a time and a money issue, which is not unexpected.
Okay, great. Okay. So, Karen, why don't you lead on then with the first topic, then, demonstrating impact and mitigation.
Okay, so this is where I think we've got some meaty, interesting questions from all of you. So thank you for those. The main message here that we kind of want to start with is that in any claim that you put together, whether that's going to be running to formal dispute or used for commercial settlements, the burden of proof lies with the injured party, with the party making the claim. So you are the guys, if you are that injured party, you are the guys that are going to need to put that claim together. So that's the overarching, you know, that's the overarching background to this particular area. So if we go into the first question then, John, there's a question here saying, and we're not going to slag off lawyers because we love lawyers, but what about lawyers saying that it's not force majeure unless you demonstrate that, one, it's affected you and that you've taken all reasonable measurements? So the question is, who determines what is reasonable measure in the current circumstances? So what is reasonable?
I think we have to go back a little bit further than that to ask the question, what is it that was causing you to be prevented from fulfilling your contractual obligation? Mm-hmm. That's the question that needs to be established first off, because that will take you to the situation of how you can actually do something about that. Mm-hmm. And, you know, we've got some examples elsewhere about, you know, if it's a vendor and they can't deliver equipment, then do we have to claim, do we have to assess and establish that all vendors were affected by force majeure? Well, of course not. It's the ones that are preventing you from meeting your obligations. So, for example, you may have a large piece of equipment that's on a critical path, pushes out the completion date, vendor can't deliver. That's where the focus of attention needs to be. Now, there may be a series of vendors in that situation, but it isn't going to be all of them that's on the job.
Every vendor.
So you have to go back to what's causing it and why. I'd like to come back to the mitigation a little bit later. I think we've got some other issues there. So we just park that one for a minute, Karen.
Yeah. Okay. So the second question is, if there are restrictions from national governments, which we've seen in some cases, that lock down the country and stop manufacturing activity, and this comes back to your point here on suppliers, John, does a contractor have to prove that every one of the suppliers of such countries who suffered the FM event, or does he have to show a particular all the correspondence to the client, or is it just enough to prove that there is a lockdown?
It goes back to that first question. It's what is preventing you from fulfilling your obligations. So it might be one, it might be multiples of vendors. And yes, you need the documentation. You need to show that that vendor is prevented from delivering to you because of, in this case, force majeure, COVID-19. And you will need documentary evidence for that.
And this is the cause and impact thing, which is key in all claims. So, you know, just proving that there's a lockdown from a date A until a date B is not sufficient. You know, that will not be sufficient. So I hope that's come across in our previous webinar. A related question is how can I ensure that one supplier is not overestimating the impact of force majeure and trying it on, you know?
It goes back to where you started with the one that's making the claim, in this case, the vendor, has the burden of proof. And therefore, as the employer, in this case, whatever that relationship is, you have the right to be able to say, okay, prove your case. I don't believe it's force majeure. You prove it to me that it is. And then you can go get across that hurdle, and then you can say, okay, well, what is the true impact? And again, I think we're coming on to that in a minute or two, is in other questions.
And I guess a key decision here for anybody is, are we going to join forces along the supply chain and put together a coherent common claim, or are we going to individually fight our own corners with potentially different arguments? And that's common to any claim situation, but particularly so here. So I'm not sure what the answer is that, but it's a strategic decision that people will need to make.
And just on that point, I mean, to try and deal with it individually in each case,
it's going to be difficult.
It's difficult in the task anyway. That would just factor it to make it virtually impossible. So there does need to be some real collaboration there along the supply chain to get the story together. And to control the situation.
Yes, because you all need each other at the end of the day. So something we started to talk about in the last webinar was we had a question saying let's suppose that in a project there are pre-existing delays for supplies with respect to the baseline schedule. The question here is, though, is there still enough float for those supplies to arrive on time just before the moment that the coronavirus impacts do cause the impact on the critical path. So that the items have made it to site, they've got there. Can the contractor use the force majeure clause? And the second question related to that is that the client's position states the supplies were late anyhow, and what is late in this case?
Yeah, I mean, it's a very good question. Let's go back to the basic principles of force majeure, which is to relieve whoever's suffering from force majeure from their contractual responsibilities there, the liabilities.
Mm-hmm.
So it's delay.
Mm-hmm.
So if the force majeure event, this is a pre-existing delay that's pushing out the completion date, or even if there's not a pre-existing delay, if force majeure, if the event doesn't, and the delivery or whatever it happens to be is not on the critical path and does not push out the completion date, then it's an irrelevance.
Mm-hmm.
So yes, there might be force majeure as an event, but it has no consequence.
Mm-hmm.
So it then becomes a no claim. It doesn't fly. If we look at a pre-existing delay that, let's say for the sake of argument, is the responsibility of the contractor here, and there is a late delivery by vendors caused by force majeure, that doesn't go beyond the effect of that already established delay, then we don't have concurrency here.
Mm-hmm.
This is subsequent.
Yes.
And therefore, if it's no greater than, if the force majeure event is no greater in delay impact than the existing delay, then it's unlikely that there will be any entitlement to extension of time. But if the effect of the force majeure is greater than the pre-existing delay,
exactly,
then the delta would probably result in an extension of time.
Yeah.
For that, that extra
that
amount
item.
of time.
Yeah. So, a clear, an analysis showing the impact of the affected items on a critical path is going to be really important in demonstrating any case for this, isn't it? And it sounds easy to do, but as we know, it really is very, very complicated. And if you couple that with the previous question, which is, how do we ensure that our various suppliers are not overestimating and already building into the fact that they're already going to be negotiated down, then it becomes a mammoth exercise. But
and that's why one needs to be very selective as to what is it that's actually impacting us here. What's preventing us from meeting that completion date or whatever the other obligation is that is the subject of the force majeure claim.
Yeah. Okay, so slightly different topic that we had a good question on is what do we do in an owner's engineer contract? So somebody who's PMC or owner's engineer, where their client's EPC contractor has declared force majeure. So what should the owner's engineer do?
Well, I think there's two issues to consider here. First of all, your terms of reference as the owner's engineer under your contract with the client, and are you in the requirement to advise on a contractual issue such as this? And if you are, then you better advise them and establish whether or not the contractor's claim is valid or otherwise, and advise the client accordingly. The second point is that you are a contractor with that same client, and therefore that force majeure event may or may not affect your ability to deliver what it is you have to provide under your contract with the client. And if therefore you're affected by COVID-19 or force majeure, then you better serve a notice under that contract, assuming there's a force majeure provision in that contract.
And if you're working, a lot of these contracts are on a reimbursable basis. Just because you've potentially got an extension of time, you're going to need to demonstrate the additional costs if your people are required to be on site or at the client's office for an extra 3, 4, 6 months. So there's going to be significant costs incurred there. Yeah. Okay, so maybe we should just talk a little bit about mitigation, and this is got the potential to get misunderstood, and the potential ramifications of misunderstanding it could be very, very costly for people. So we got a good question saying, you know, normally contracts indicate that we've got an obligation to mitigate the impacts of force majeure events, which actually is true, but there's normally an implied requirement to do it, even if it's not mentioned explicitly. But could it be the case that the possible measures are extremely costly, and then, for example, all the project benefit disappears if we implement these measures? So yeah,
Good
so.
question. Again, first of all, let's just consider what mitigation is from a risk management point of view. And there's all sorts of definitions, but I think there's a common one that is mitigation means reducing the risk of a loss from occurrence of any undesirable event. So it's about reduction, it's not about elimination. And if we look at the root of the word mitigation, it comes from the Latin mistis and agere. First means soft, the second is do or act. So it really means to make soft. So it's, and again, if we then take that to a dictionary definition, it's the act of making a condition or consequence less severe. So again, it's not about the elimination of the consequence of the event. And basically in contracting terms, it means you can't take advantage of a situation for commercial benefit, and you are obliged to simply make it less severe. So you're not making it worse. Now, custom and practice says that in those circumstances, you're not obliged to spend your money to make it less severe. So the cost of the mitigation is not a consideration, because you don't voluntarily say, well, we'll fix it for you, dear client, unless the express language of the contract is that you are obliged to use best endeavors, which go way beyond reasonable endeavors, particularly under common law contracts, and you will be obliged to spend your money. So you need to look very carefully at the contract before you sign it.
A bit late, yeah.
And certainly at the time that you have contracted and you're faced with this problem, ordinarily you don't take action that incurs you in cost unless you've contracted on the basis of best endeavors. Then you've got a problem. And then what becomes reasonable? Well, in the classic sense, it's the man on the top of the London omnibus. I've never really understood that, but that's what they tell us. Reasonableness is a difficult test, of course. And it is whatever is reasonable in those circumstances, and ultimately how a court would see that as being reasonable.
Okay. Yeah, I mean, I think that's great. Please, you know, it's about not spending money in simple terms, but we know it's not as easy as that. But if you do, keep records, and that's going to be another theme that we'll come back to. Okay, so we're going to move on to some related questions. These are all interconnected, which are more around foreseeability. So we had a question, if COVID-19 is now foreseeable, would you say that future pandemics like this one are foreseeable?
No.
No, I agree.
It's each event as it comes up.
Yeah.
You have to deal with it, and the foreseeability test is from the date the contract was signed. Not the date the event occurred.
Yes.
When it occurred, you can definitely see it.
Yes, absolutely, absolutely. But also getting, you know, this pandemic is going to have a tail and some bumps. You know, this may, you know, be with us for some time as we're all learning, and it may come round again almost. In which case, at that point, it is foreseeable. But it really comes back to getting a very clearly worded force majeure clause, or getting an opinion on the interpretation of your force majeure clause, or the underlying, if you're in a civil code area, the underlying civil code. And the complexity of this is illustrated in another good question on that, which is sort of saying coronavirus as such may have been unforeseeable, but in terms of parts of Europe, we could virtually have seen it coming if you were quick. So if I had notified FM in February due to coronavirus in China and did not provide the opportunity for home office work in Europe early enough, then did I not do the reasonable efforts to mitigate, and can I then also not claim that it was unforeseeable because we saw the impact in China? And as you say, John, the foreseeability test applies at the signing of the contract, not midway through it. So you're fine there. But if you're, we've talked about mitigation. So you need to do what is reasonable, but not broadly not spending your own money to mitigate this. So you will need to put arguments together as to what is reasonable and what is not, because as I say, it's a subjective assessment.
And right at the moment, we're talking about force majeure.
Yeah,
we will be coming on to other issues where it's a little bit different.
Yeah, absolutely,
yeah.
Absolutely. So just a couple of quick questions on notices. Notices of force majeure, but also questions around people wanting to know whether they should put notice in for potential alternative or additional claims, such as change in law, which we're going to come round to. So one question was, some contracts require impact notifications for force majeure events from a specified time after the event was known or should have been known. COVID-19 may acknowledge to be a force majeure event early on, but it doesn't affect the project until much later as the restrictions gradually increase over time. And another related question is, if the performance is not actually yet impaired by COVID-19, should a notice still be given? And I think we've got a common answer to both of those, haven't we, really?
Yeah, I think that first of all, a notice is not a claim.
Exactly.
It's a notice to advise.
And it doesn't have to be followed by a claim. Get the notice in. You don't have to follow it up with a claim.
No, I've served hundreds of notices without there being a claim. So it's about contractual compliance. And the whole purpose of notice is to alert the other party to the fact that there is an event actually occurring or impending that may actually incur some damage one way or another, delay or cost or whatever in terms of notices. And therefore, it's wise to serve a notice. You can follow that notice up and say, at the time of the first notice, we couldn't actually assess whether there was going to be any impact or not. Now we can.
Yeah.
But at least you will have complied with the contract and kept the other side alert to the possibilities of there being a delay or whatever the consequences may be.
Absolutely.
But the second part of the question was?
Well, the second saying if the performance is not actually impaired, should a notice be given? And it's the same answer. Yeah, get your notice in. You don't necessarily know when, if, how the project is going to be affected, but get the notice in early, and as soon as you should have known, which is already happened. And then you can work out and then be discussing with your client, with your subcontractors, how you're going to manage it. So the third question, which is going to lead quite nicely into potential alternatives as well, John, is would issuing a notice of force majeure prejudice the position later on to claim under an alternative part of the contract, like claim a change in the law?
Goes back to the very first question. What is it that's preventing me from fulfilling my contractual obligations? What else is happening on the project, basically, it runs in parallel with that. So we have a situation today with COVID-19 where there may very well be force majeure event as a result of that. But there may also be changes in law, which we do know, and again, it depends on circumstances, what the contract says, etc. And therefore, there may very well be a need to serve two separate notices, one that deals with force majeure, one that deals with possibly change in law, because they have different regulating conditions under the contract. And you're probably looking at different remedies for both routes. So force majeure is one, change in law is another. There may even be others that are considered. So you have to go back to what is it that's actually hitting me, and how do I deal with it in accordance with the contract.
Yeah. And we had various questions raised to us about some specifics on the varying governing laws, like Sharia law and the French Civil Code and other things. We don't have time at the moment to really address those, but you will need to look at what the principles of force majeure are under the specific governing laws where your contracts are operating, which may be several, and probably get formal legal advice depending on where you're wanting to take this. But we could discuss that today, but we really don't have enough time to go through it. And as I say, I think really you should be getting some legal advice if you feel that you want to look at remedies under the law.
Yeah, and just to add to that, we've got the different legal regimes, but if people talk about civil code, well, there's a principle of civil code of a type of law, but the different countries have different rules on how they construct their civil code. And therefore, it isn't just a matter of saying, oh, it's civil code and it's X, Y, and Z.
They're all different.
It's very different. And particularly over things, how the particular law governs issues like force majeure, for instance, because it is quite different on the different regulations. And then, of course, we have the common law basis, which doesn't even recognise force majeure, and we do something else. So it's really, I completely agree, advice needs to be taken on what the law says, and there's only lawyers can really give advice on that.
Okay, all right. Thank you both. So for the first part here, we've been mostly discussing force majeure. But what about the alternative options, particularly if you're looking to recover costs? So Wayne, maybe we can bring up the next poll now, if you could. And this is a question on, what are the other ways in which you're planning to recover time and or money? And the options you've got there are change in law clause, variation instructed by the client, a suspension clause, governing law provisions such as good faith or prevention, or any others, and also breach of contract. So let's give you a few moments to consider your options there. And while you're doing that, just want to remind you again, in the last 10 minutes, we're going to be dealing with as many questions as we're able. I'm seeing some being filtered through to me now, but I'm sure there's probably plenty more from you. So let's just take a look at the results of that poll then, if they're ready there, Wayne. Okay, so two kind of standout choices there: changes in law clause and governing law provisions. Okay, thank you for that. Karen, let me hand back across to you, and let's move on to the next section then, I think, which is this alternatives to force majeure.
Okay, thanks. And that's quite interesting, those the poll results. And we're going to talk about the change in law option here. There are many alternatives, certainly under common law. The idea is that you're two grown-ups who've signed two business entities who've signed a contract, and the contract really is providing for the potential remedies, the obligations under that contract for performance, and the remedies if either party is prevented from delivering those. So reverting to some common law principles like prevention or frustration and that sort of thing are there, but the bar is going to be really high for anybody to successfully argue that, particularly if, as in most of our contracts that we see, that there are remedies provided. And one of those remedies is a change in the law clause. So I'm going to pass over to you, John. The first question on this is saying, if this, if the pandemic is not listed as an occurrence under the force majeure clause, could we approach this from a variation perspective and claim cost and time? And is change in the law one of those potential options where we're also looking to look for money as well as time?
Well, it's a very good question and quite complicated because it depends. I think first of all we have to go back to what is causing the prevention of performance and who is it affecting? Who's affected by this? Because we can have a situation where the force majeure is neutral in terms of the employer and the contractor. So if the owner is affected by force majeure, but pretends that it isn't and doesn't serve the appropriate notice, and let's give as a classic example an owner's fundamental obligation to provide the access to the site or possession of the site, and he just happens to choose because it suits him in this circumstance, well, we'll shut the site down for whatever reason, and we've had some questions from around the world on this. Then how do I deal with that from a force majeure point of view? Well, it's not force majeure, it's breach of contract. It's an entirely different claim. The fact that the employer in that situation chooses not to invoke the force majeure clause for whatever reason, that's his choice. But there are consequences because the force majeure there is to avoid him being in breach of contract for not giving access to the site, in this case, access to the site. So you've got to look at the situation and say, okay, what is actually going on here? And who should be invoking the force majeure if it is force majeure? Now, if it's a change in law, then you've got to be able to establish that it is actually a change in law. First of all, what does the contract say? Because some contracts are very broadly defined as to what constitutes change in law, and some are very narrowly defined. And it's very difficult to prove a change in law. So it's look at the contract and then look at what that change in law is and what does it actually affect. And some contracts may say, well, if it is a change in law, it's dealt with under the variation clauses, which it could be.
Maybe.
Or
it
not.
May be.
It could be standalone.
Yeah.
So you've got to know your contract pretty well here and look at the circumstances. Why is it a change of law? What is it to support the fact that it's a change of law? And there must be evidence that it does change. And then deal with it from there. So the answer could be, as the Germans say, jein.
Okay, and relating to that, we had a question to saying, is it reasonable to consider the different orders and instructions from the authorities as a change in law? Or are these instructions the direct consequences of the pandemic and therefore really part of a general force majeure event? And I think there's two parts to that question, isn't there, really? So
well,
an order and instruction from the authority may or may not be an actual change in the law, yeah?
Exactly.
Yeah.
If a government is using existing powers, emergency powers, to deal with this situation in their particular country, then it's a use of an existing law. It's not a change in law. It might only be used once every 10 years, but it's still the existing law. So it's not a change in law. And again, it depends what the contract says as to whether it deals with the utilization of laws that, in these situations. It just depends on the wording of the contract. So it could be or it couldn't be is the answer.
And the other question, which was, are those instructions a direct consequence of the pandemic and therefore part of the force majeure event?
It depends.
Again, it could be, but it really also depends on where you're trying to get to. I mean, bearing in mind that the claim that you're putting together is presumably because you're wanting to seek some financial recovery for your losses. then this is the strategic development of your claim in terms of how you want to present it to give you the best chance of being able to put some
Exactly.
money on the table. Yeah.
And you may very well have two claims going in parallel here. You may have a force majeure driven claim for extension of time only.
Yeah.
And assuming that there is a change of law situation which has a different effect.
Exactly.
Force majeure is going to be critical path, most definitely. But the change in law may affect the performance of non-critical activities, deployment of labour, productivity issues, all those sort of things, that have nothing to do with critical path, but cost a hell of an amount of money.
Yeah.
And if the change in law provision is satisfied, then it would be a financial claim and possibly a critical path claim, depending, as a result of the change in law. So you'd run two. And on large projects, that's perfectly feasible, because you could have those two very separate impacts.
Yeah.
And therefore, when you're looking at time spent on the project prolongation costs and productivity issues and things like that, they're quite separate from entitlement to extension of time.
Guys,
yeah, go on, Carl.
No, go, please, Karen. Sounds like you're about
Well,
to
I just wanted to add, we'd had an interesting contribution from one of our connections on LinkedIn just shortly before the webinar, talking about different ways to break the project down by area. If you've got a big project, there may be parts of the project that are completely unaffected by this, and there are parts that could be severely affected by it, and they could be affected by it in different ways. So it could be impacts on the critical path, force majeure issues. It could be impacts via potential breaches of contract, which interestingly nobody on the poll said that they were thinking of pursuing that as an option. And we would suggest, there will be instances where you could be making that argument. So I think it's a very valid point, is you don't have to treat, particularly for big projects, this as a one massive project. You can break it down into particular areas depending on where they are, their levels of completion, and the amounts that have sort of been affected. And so it really requires quite a complex strategy to put together all the potential different arguments, but in a considered way, rather than just throwing anything that you think will stick. You really need to think it through. So sorry, Carl, that was all I wanted to say.
I'm jumping in because it sounds like we could talk for a long time on this particular subject alone, and perhaps that's another webinar in the future. I'm getting conscious of the time, and we've got questions flying in. So I wonder if I can kind of move you along to talking about the signing of new contracts, and maybe if we can spend maybe 3 or 4 minutes on this, and then maybe we'll move on to the questions. Okay.
All right. Okay.
Great.
So, many of you, we did have some questions. One question is, can COVID-19 still be added in the force majeure clause in a new contract? Since it's not unforeseeable event now, it doesn't make sense to me. And one of my suppliers is wanting to insert it. Well, it doesn't stand the test of foreseeability anymore. Other pandemics might be included, but if you're at the point of almost signing a contract, then it would be worth absolutely looking at your force majeure clause, whichever side of the fence you are on, to see what that would do and what would happen. And you could play out some scenarios of what would happen if this thing bounces along for another 18 months. What would happen if there's a new we've had COVID, we had SARS, we had MERS. So please have a think about that. And the good practice, really, I think, that we would want to encourage everybody to do, to say, if your contracts are already negotiated and priced, can both parties still deliver what they were obligated to do under the plan and the price? Because if you can't, then you really need to go back and renegotiate. Check all the relevant clauses, and this is about what could be the potential events going forwards, and have some scenario planning with the key parties up and down the supply chain. It's no good doing an ostrich impression and putting your head in the sand saying this isn't going to happen again. This is our new potential world. So please talk openly about this and say, what would we do if this event occurred, and how was it provided for in the contract? And one final question, quick question on this with a very simple answer, which was, will the signature of the contract by two parties, given the current circumstances, trigger a force majeure, or does the signature of the contract, knowing the conditions, mean that the parties accept the pandemic and waive their rights? The latter. You have waived your rights. If you sign a contract, this is now foreseeable. So please go back and have a look at your contracts that you're about to sign, and please review that. So hopefully, Carl, that was quick enough. And do you want to add something, John? Sorry.
3 seconds. The language used in modifying the contract to accommodate the COVID-19 continuing effects, which is what it is, needs to be very carefully crafted.
Yeah.
I agree with all the things that Karen said about scenario planning and that, but at the end of the day, the contract has to be modified to accommodate the contractual legal consequences of this continuing, and it needs some careful wording.
And as we've seen here, not just the force majeure clause, but any change in the law clause, anything else where all the different places where we've already been talking about remedies, if this were to happen again.
Yeah.
Okay,
Great, super. So I'm going to move you guys swiftly on to some questions that have come in, and we're better placed than to start at the top. And here's a question by Andre. If the level of the workforce is limited at site by the main contractor because they can't provide facilities or welfare to have any more, is a claim on the basis of an impediment by the main contractor possible? What are the challenges? Can the claim be made in parallel or together with a claim on the basis of force majeure? Asking for a friend. What do we think? Do you want to deal with that, John?
Yeah, I think this again, you have to look at the circumstances and the obligations and what's being prevented. But unless that party has served notice of, let's say, force majeure here as their reason for not making available utilities, etc., that are required by the contract, then fundamentally they're going to be in breach, because they're not delivering what they should deliver to enable the other party to deploy and carry out the work. So it's a very different claim, and no doubt, it depends on a lot of facts. But what it sounds like is someone not meeting their obligations and just deciding not to, rather than linking it to a force majeure event or a change in law event or anything else. So therefore, they carry the consequences. But it's about fact and it's about the contract.
Okay.
And you can call it whatever terminology in the contract, but it's failing to meet their obligations, basically.
Okay, thanks for that, John. I hope that answered the question for Andre. One from Ramon. So Karen, let's put this to you. The contract was signed previous to COVID, coronavirus, but certain subcontracting has to be done now if the schedule is not to be completely abandoned. Firstly, can we delay contracting under force majeure if the subcontractor is reluctant to accept signing now? Or two, if we do contract, can the owner deny us force majeure for any of these subcontractors late to for any of these if the subcontractor is late hit on by COVID-19?
Well, I think the second part is probably easier than the first, is that if you are in the process of signing contracts with your subcontractors now, you need to take this into account in whatever way. The plan that they may have offered may need to be extended, etc., which is something that you will then look to recover from the ultimate client. But you can't just blindly sign the subcontracts now, stating that you're just going to follow almost on a back-to-back basis what was in the head contract, because the situation has changed. And then as a result of that, you need to then look upwards as to, well, what obligations am I prevented from delivering to my client as a result of the subcontractors not being able to perform in or offer a price or a schedule in the way that we had anticipated that they would, and therefore that gets built into your claim upwards to your client.
Okay, super, thank you. We do have many more questions, but I realize we're running out of time. So John, maybe I just hand across to you for a few final words on getting a case together, and a tool that we've used here at Kingsfield to help us do that. Hopefully you're going to see now something to help you with that. John,
Yeah.
Here we go.
Yeah, what we use in Kingsfield is something we call the 7 key factors, and it goes back to what Karen said at the beginning, that the party making the claim has the burden of proof. And we've looked at what burden of proof means, and we've come up with these 7 factors dealing with cause, responsibility, liability, impact, entitlement, compliance, and evidence. Put those together in any claim situation, and you will probably satisfy your burden of proof obligations. For each of these headings, we have a more detailed explanation of what we're actually talking about. It's not just as simple as talking about cause. What does cause look like, etc. And anybody that's interested that would like to see a bit more detail about that, we'd be happy to hear from them, and we'd be delighted to provide that further information. And we do find it is a good guide for making claims and for defending claims, because it's the same test. It's only looking at it through a different prism.
Excellent, thanks, John. Thank you that brings us to the end of the webinar, and consistently over time, unfortunately by a minute, so blame myself for that. Thank you to John and Karen for sharing your thoughts and comments on the questions. Thank you to all for joining. Thank you to everybody that posted questions to us. There are a lot of questions we haven't been able to answer. If you would still like answers to those questions, please reach out to one of us here, and we'll do our best to get back to you. And if there's something particularly about your project you want to discuss, then of course we can speak about those too. And also, if there's any subjects that you think you would like to hear us talk about, which we haven't yet spoken about, then drop me a line and I'll try and squeeze that into our schedule. Other than that, thanks again. Stay safe, and this video will be up on YouTube, on our YouTube channel in the next few days. So thank you very much, and until next time, stay safe.
Yeah. Take care, everybody.
Bye.
Yeah, take care.